I'd like to welcome everyone to the 2018 reorganization meeting. In accordance with the state sunshine law, adequate notice of this meeting is provided by sending a notice of time, date, location, and the extent known in the agenda of this meeting on January 3rd, 2017 and December 22nd to the Princeton Packet, the Times, the Home News Tribune, the West Windsor-Plainsboro Public Library. Copies of the notice have also been placed in the board office in each of the district schools on January 3rd, 2017, December 22nd, 2017, and sent to the Plainsboro and West Windsor Township clerks on January 3rd, 2017, and December 22nd, 2017. This is a reorganization meeting of the West Windsor-Plainsboro Regional School District. This meeting was advertised as stated above. The results of the election of November 7th, we wrote, without going through all the numbers, counting endlessly, we realized the results are that we had Ms. Krug, Mr. Whitfield, and Mr. Cheng were the winners of the election. Okay. Given that, I'd like to open the floor for nominations of President. Oh, okay, Mr. Leo. Sorry about that. I'm a little wound up. I apologize. So what we do here is we don't stand up and do all that. So what I'm going to do is I'm going to ask from your spot that you have an oath placed before you. That's the half sheet of paper. Just the half sheet. And what I'll ask is that, yes, just the 3 new members will read that. What I do want to say to everyone before we start that is you have a packet of information before you that has the ethics, the 10 paragraphs of the ethics training, etc. You have to sign that. However, we have a better packet from our attorney that has presented one that's put in front of you as well. So all I need is when you're done, when you read the 10 paragraphs, the code of ethics, please sign that cover sheet and make sure I get a copy before the end of the night. I will hunt you down for it because it is part of QSAC that we have those. So what we're going to do now is we're going to start with Ms. Krug, and she's going to read the oath of ethics. I mean, not the oath of ethics, the oath of office. Yes, that's right.
I, David Krug, do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of New Jersey, and that I will bear true faith and allegiance to the same and to the governments established in the United States and this state under the authority of the people. So help me God. I, David Krug, do solemnly swear or affirm that I possess the qualifications prescribed by law for the office of member of the Board of Education, and that I will faithfully, impartially, and justly perform all duties of that office according to the best of my ability. So help me God.
Thank you. Congratulations. And please sign the. Next, we'll go to Mr. Whitfield.
Thank you. I, Whitfield, do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the State of New Jersey, and that I will bear true faith and allegiance to the same and to the governments established in the United States and this state under the authority of the people, so help me God. I, Martin Whitfield, do solemnly swear or affirm that I possess the qualifications prescribed by law for the office of member of a Board of Education, and that I will faithfully, impartially, and justly perform all the duties of that office according to the best of my ability, so help me God.
I, Isaac Cheng, do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of New Jersey, and that I will bear true faith and allegiance to the same and to the governments established in the United States and this state under the authority of the people. So help me God. I, Isaac Cheng, do solemnly swear that I possess the qualifications prescribed by law for the office of member of a Board of Education, and that I will faithfully, impartially, and justly perform all the duties of that office according to the best of my ability. So help me God.
Okay. I guess hearing nothing else at this time, I'd like to open the floor for nominations for president.
I nominate Tony Blair for president.
Okay, any other names? Hearing none, the floor is now closed for nomination. Before you, you have a sheet of paper that's white. Please fill that out if you, with your vote, Tony, or whatever you want to write in. Hold it, please pass it. Yes, secret ballot.
Use ballot, you just have to announce that each member voted. That's pursuant to the Open Public Meetings Act.
Okay, the first vote is Donald Duck. No. Okay, the first vote is Mr. Whitfield. It's for Tony. Next vote is Ms. Hurst for Louisa. Ms. Hell, I should say. Apologize. Mr. Chang voted for Mr. Flair. Ms. Juliana voted for Mr. Flair. Ms. Crew voted for Mr. Flair. Mr. Flair voted for Mr. Flair. Ms. Case voted for Mr. Flair. Mr. Taylor-John voted for Mr. Flair. And Ms. Ho voted for Mr. Flair. So it's 8-1. Congratulations. Turn the meeting over to you.
Thank you. I thought about having something to say, and then I was told you're supposed to be grateful, be humble, and be brief. So now I'm going to take nominations for Vice President. Open the floor for nominations for Vice President.
I'd like to nominate Tom Page for president.
Okay. Any other nominations? Hearing none, we'll close the floor for nominations. We all have a blue slip. Please fill that out and pass it down to Chris.
Okay, so the results. Ms. Hurst for Ms. Ho. We have Mr. Chang for Ms. Case. We have Ms. Crew for Ms. Case. Ms. Juliana for Ms. Case. Ms. Ho for Ms. Case. We have Mr. Whitfield for Ms. Cage. We have Mr. Taylor-John for Ms. Cage. We have Ms. Cage. And we have Mr. Clarice for Ms. Cage. Congratulations.
Okay,
When you're speaking to the mic,
can I have a motion on
you
the
should be about
reorg
a hand's
items?
width from the mic. No, don't swallow it, otherwise it's too loud. Okay.
It's agenda item 7 through Roman numeral 33. Can I have a motion on those? Dana and Rachel. Any questions or discussion on any of them?
I have a question on 21.
We're not looking.
December 18th date.
33.
What I experienced this year is that my kids go home from college by December 18th, and I cannot attend the meeting, so I would request that meeting be either a week earlier or held in January. And I assume other parents have the same problem.
It's the special for the December.
It's too close to Christmas.
I don't see it. Taylor, I don't see it.
You can always look at it, leave it here, and then reschedule it as time as it goes. So we'll leave it as a, there's no objection, leave it as a date, and then we'll confirm it as we go along. That's usually the way our special meetings go anyway. Any other items?
Okay, we'll start with Ms. Krug.
Yes.
Next is Ms. Juliana.
Yes.
Mr. Chen. Yes. Ms. Hurst.
I'm going to say no on item 20, and yes on item 9.
Next is Ms. Houghton.
Oh, yes.
Next is Ms. Houghton.
Yes.
Yes. Okay. Mr. Whitfield.
Yes.
Mr. Taylor-Johnson.
Yes.
Ms. Gage.
Yes.
And Mr. Flaherty.
Yes. Carol, I just want to be sure, just to clear, you were voting no on 20, not 21.
Correct.
Okay.
And I just want to say I apologize for going 23 years of taking the first and second and running with it. That's what I did right there. Catch you on quick.
Okay, that brings us to our regular meeting. I just want to thank everyone for coming out. I hope you all had a enjoyable holidays and were able to withstand the cold weather. It'll get better in a couple of months.
Good evening, everyone. First, I want to welcome you back to our first board meeting of the new year. And let me begin by wishing everyone in the audience and watching on videotape a happy and healthy new year. I'd also like to welcome back to the Board of Education Dana Krug and Isaac Cheng, who are both elected and taking the oath this evening. Also welcome our newest board member, Martin Whitfield. Welcome to joining us at the table. January is School Board Recognition Month. This is a time to recognize the contributions of our board members in both Plainsboro and West Windsor for their volunteer service that they demonstrate to our community. Please accept on behalf of the administration a book called Turtles All the Way Down by John Green as a token of our gratitude for your dedication. Also on the agenda tonight, you'll be recognized and honored for your service so that the parents, students, teachers, and staff members and community members can acknowledge your contributions. Your work always brings us forward with a high-quality education for all students as you advocate for public ed. And on behalf of the staff, students, please accept my thanks and appreciation for all you do for our community. I'd also like to bring a couple matters to everyone's attention for this evening. On January 9th at Brown University, we'll be hosting the Mercer County Superintendent's call to action regarding mental health and suicide. George Scott from the Traumatic Loss Coalition will be our keynote presenter, and we do have representatives from at least 8 different organizations that will be in attendance supporting us that evening. It will be at the Cavella Room, which holds about 750 seats. So it's a first come, first serve, but with 9 communities being invited, we do anticipate it filling up. On January 3rd, tomorrow evening, the West Windsor Township has a review of their master plan report. That's at 7 o'clock in the municipal building. I would encourage anyone who's interested in hearing about the master plan report to go out. It's on the township website. It's a fun read that does have one page on the school district, but we'll be making sure that we're there tomorrow night to represent the school community. On January 17th, the Planning Board is going to be holding a courtesy review of the Maurice Hawk edition, again at 7 o'clock on January 17th. That public notice went out to a break, just for the timing of how that went. So again, just so the public is aware, on January 17th. I believe at the January 23rd board meeting, January 24th, we're working on solidifying the architect's availability, but we'll be doing a presentation in front of this body as well. Regarding COA, which is the certification of affordable housing, as of yesterday, we were still waiting for the numbers. I did not hear anything different today from the township staff, so that we are still waiting for the judge's determination of either one, a number, or two, a methodology to determine the number. So we are anticipating that. We've been anticipating that for 2 months now, so we're anticipating that any time. Additionally, I'd like to say just publicly thank you to Senator Turner, Senator Greenstein, and Assemblyman Benson, Assemblyman Quijano for their support, and Senator Allen as well. 2 bills, Senate Bill number 3447 and Assembly Bill 5254. Both are with respect to cooperative sports arrangements, working with the senators and Assembly men and women to ensure that we have opportunities for equal access for our athletes on the playing fields. Those bills are both moving very swiftly, and there is opportunity still for them to be in front of Governor Christie by the end of next week. So we do expect that those bills will be moving forward on Thursday of this week, and again on Monday of next week, and then ultimately in front of the governor before his term for his consideration. What that would do is allow school districts with multiple high schools the opportunity for pool programs to combine for any sport, not just football. The recent NJSIA legislative changes is for football only. This bill it removes the restrictions regarding postseason play, and it also allows us to consider any sport the ability to co-op, which is currently in violation of the NJSIA rules and regulations. And lastly, I believe joining us in the audience, I believe I saw our new Township West Windsor liaison, Judika Dorari, who will be joining us. She was appointed just yesterday. We wanted to welcome her to the audience, but also to Tony and I, and Dana, and Wazine in the back, and Martin were able to attend the ceremony at the township offices yesterday, where Hamad Morante was sworn in as mayor. Ms. Hamilton, Ms. Miller were continued their terms, and also Ms. Jeevers and Ms. Manzari were sworn in officially. So I believe Plainsboro is tonight, if I'm not mistaken. So the Plainsboro reorg is today. I'll give you an over-under on who might be the mayor. So that's it for my report. Thank you.
We have a student representative.
Hello, everyone, and Happy New Year. As you all know, today was the first day back, and although we're all very tired, we're starting to get back into the swing of school and welcoming in 2018. The Spring Musical Sister Act has been casted and has started the rehearsal process. And despite the cold, sports teams have been working harder than ever. The swim team actually got to escape the icy cold during this winter break and trained in Florida, swimming 31.5 miles overall. The winter track team has a meet tomorrow as well, and the student council has been furthering their preparation for their winter spirit week and fundraiser next week. Thank you all for your time. Let's all cross our fingers that we have a snow day this Thursday.
What a plug.
Okay. I'd rather have the day off when the weather was better. All right, that brings us to the annual Board of Education annual ethics training. And our board attorney is going to give us a presentation.
Usually I don't need a microphone. My voice is loud enough. Is it coming through? You okay? All right. As Mr. Russo indicated, in front of all of you is a packet with a page clipped in front. We ask that you please sign this form, give it back to Mr. Russo so that all the board's record keeping is complete. This presentation, as well as all the handouts that were given to all of you, will also be incorporated into the board minutes. And as in years past, a PDF copy of this presentation will also be available on the board's website as well. So without further ado, we'll delve into our annual discussion of the School Ethics Act, which we are required to have. We break this down into topics. We review and analyze the School Ethics Act itself, rather than just look at the 10 tenets in a vacuum. I try to give them to you in context, to give you the factors that the School Ethics Commission would look at if there was an alleged violation, and to give you some practical real-life examples where board members, not here, but for other districts, have run afoul of those tenets. By far the biggest issue that the School Ethics Commission dealt with from our ethics presentation last January to now has been negotiations and the chain of command provisions, meaning who can and cannot participate in collective negotiations, the various associations, as well as who can and cannot participate in various personnel decisions within the district. For everyone's point of reference, I did, so your necks are not straining. In the packet I gave you, all of the slides are attached as Exhibit 1, so you can kind of see it as we follow as we go. The other big areas of concern or retractions that we've seen is the role that board members are allowed to play in interviewing and making personnel decisions, the extent that board members are permitted to volunteer, and the provision of shared services. What has been particularly interesting within the last 12 months is that the Ethics Commission stopped issuing decisions. Go on their website, the last public decisions that they have were entered in August, and there's nothing since. And in the past, where that has happened, usually they release everything en masse. Those of you that have been around for a while may remember, I think it was February 2015, all of a sudden, in one day, 33 different advisory opinions all came and released on one day. That kind of fundamentally changed a lot of how school districts operate. So I'm not sure if we're going to be looking at something like that again this year, but just in case we do want to be prepared. So it's just an overview. The Board of Ed is the governing body. The school district is charged with making high-level policy decision. It is the only entity that can enter into any contracts, but its decision-making authority is limited. Cannot administer the schools, and also cannot make any decisions or actions when the board is not in session. The sole exception to that being that there are some powers that are granted to the board president when the board is not in session. For instance, if the superintendent were to have to suspend or discipline an employee, he or she would have to receive the blessing of the board president, and then that action would subsequently be reported to the full board the next time it was back in session. Perhaps the most important thing is that the Board of Ed is governed not only by all the provisions in 18A, but is also governed by the School Ethics Act. And that has 10 items that everyone must follow. You have all 10 of these in front of you. I won't read them to you. I kind of break them down by topics. The first one is kind of the common sense one. Board members will uphold all laws. That's why you're here. You're duly elected, you're here to follow the rules and the regulations of the state of New Jersey and the state board of ed. If a challenge was brought finding a violation of this, the School Ethics Commission would look for a copy of the final decision from a court or an administrative agency finding that somebody willfully violated the law. There are not many cases here where board members are found to have violated this, with 2 examples. One from 2014, where a board member violated this provision of the code when he took it upon himself to issue a board member a vice notice, not following the proper legal procedure of seeking board authority or consulting with the board at all. Another case point was the president and other members of the board were alleged to have violated this provision by allegedly holding secret pre-meetings to get on the same page. This was not found to have been a violation, even if the allegations in it were found to have been true. The educational welfare. You're here and you make decisions in terms of the educational welfare of children, and you seek to develop and maintain the public schools. I hear a lot of times, if you've not heard it here, other districts that I do work with, I hear comments, I'm here for the taxpayers. I'm here for the taxpayers. Well, no. I mean, that is a factor. You are primarily here to make decisions the educational welfare of the children. Evidence of a violation would be if a board member willfully made a decision contrary to the educational welfare of students, or a board member took deliberate action to obstruct a program or policy that was designed to meet the needs of children, regardless of ability, race, color, creed, or social standing. Examples. Board members found to have violated this provision of the code when he released an ethics complaint against a fellow board member to the media that contained confidential information regarding the other board member's student child. The board members acted like children in that matter. Another one, a complaint alleged that a board member violated this provision by interrupting his presentation for the board policy and legislative committee concerning a new football stadium. He was upset that he wasn't allowed to make the presentation that he wanted to make, and therefore he felt that because his fellow board members did not agree with him, that they were not acting in the best educational benefits of the students. That was dismissed. Limit your actions to policy making. Board members, this is perhaps one of the big ones we see a lot of. Policy, planning, and appraisal. That is the confinement and the role of a board member. When you are here and you are in session, this is when you are empowered, but your actions are limited to those 3 areas. And evidence of a violation here would be if a board member took action to effectuate policies and plans without consulting those that would be affected by them, or that took action that was unrelated to their duty to develop general rules and principles, formulate programs, or ascertain the value or liability of the policy. Sorry. 2 examples here. We had a board member decide to conduct a site visit to assess a possible candidate for assistant superintendent. They did this without board supervision. They showed up on the job where this candidate was working and decided to try to do their own on-site observation and assessments. A recent advisory opinion noted that a board member would violate this provision of the code by regularly volunteering for school clubs, wherein they had contact with and control of students, personnel resources, and administration. This was interesting. This was a very profound advisory opinion that really worried a lot of folks. Board members all volunteer. You guys all volunteer your time. You're giving of your time, and you're always more than willing to assist. There was a concern that this would have a chilling effect on that volunteerism. Ethics Commission was concerned in this instance because the board member was the spouse of the play director. The board member was building sets for the play. He was giving direction to students. He was giving direction to staff. And there was concern from the School Ethics Commission that that line between limiting your actions to policy, planning, and appraisal was being blurred. I can very happily report that the Ethics Commission, as I'll show you a little later on, has been steadily walking back from this prohibition against board members volunteering. Ever since this advisory opinion came out in February of 2015, they have been chipping away at this and allowing more contact with students and their staff, so long as it is not on a regular and consistent basis. And I should have mentioned this at the outset. If any of you with any questions as we go, please feel free to stop me. You don't have to wait until the end. Kind of building off, keeping your actions to policy, planning, and appraisal. No micromanaging. Board members must carry out their responsibilities, very important, not to administer the schools, but together with fellow board members to see that they are well run. I also like to call this no giving direct orders to school personnel. Board members are not allowed to pick up the phone, send an email, call an individual board employee and say, hey, Mr. Russo, I'd like you to prepare XYZ and send it to me, and I need it no later than 4 o'clock today. All requests or actions like that have to funnel through the proper channels, which in this district is Dr. Agarwal as the superintendent. You can see this is kind of where we see board members go askew the most by the number of case points. These are always kind of entertaining. The first one was a case from 2010 where there was a board member who instructed the superintendent to allow a graduating senior to participate in ceremonies when the superintendent had already made the decision that the student would be barred from participating due to safety concerns. The board members did not have the authority to reach out to the superintendent, to direct the superintendent to take those actions. Second case point, board member violated this provision when he took it upon himself to visit the schools, take pictures of open windows in the middle school, and itemize items in the board office bathroom, which he then proceeded to hold a press conference about outside of the school. Again, another provision, the board member violated this provision when he went to the guidance office, requested a copy of SAT reports, then proceeded to go to the board's locker room to inspect the lockers, and then went to the cafeteria and decided to have lunch with the students to see if the food was any good. Again, you kind of see how that's not maintaining the actions of the policy, planning, and appraisal. And in a more recent advisory opinion, I do know that it has a 2010 date, but this was one of those ones that was held in abeyance and released in 2015. A lot of districts that I work with, when there's sometimes requests when there are a number of retirements or a number of resignations for folks move on, board members want to sit in and conduct exit interviews, and they want to know what's going on. They want to hear it for themselves. That's not permissible. That is exceeding that role. The responsibility of managing the district lies with the administration. 5, no personal promises. Board members recognize that authority rests with the board and make no personal promises and don't take any private action that may compromise the board. Obviously, evidence of a violation here, if the board member made personal promises or took action beyond the scope of their duties. Some cases, a recent one from 2014, you've had board members go and make personal promises to a candidate for assistant superintendent. This ironically took place at a bar down the shore over the summer. The board members cornered a potential candidate and said, hey, if you put in, we're going to wink, wink, nod, nod, make sure you get this job. That was obviously found to be a violation of invalid personal promise. Another case in point, a board president violated this provision when he unilaterally contacted someone newly hired by the board. So somebody was hired at a board meeting, the board president took it upon himself to call that person after the meeting, telling them that the appointment was null and void because he had already directed the superintendent to remove the name from the agenda, but the superintendent refused to do so. Again, that's making the personal promise and exceeding the role of authority. Number 6, no personal gain. Board members will not refuse or surrender their independent judgment to special interest or partisan political groups or use the schools for personal gain or for the gain of friends. Evidence of a violation would be if a board member took action on behalf of or at the request of a special interest group or somebody with whom they had a particular relationship or cause. Some examples here. Board members are permitted to endorse candidates for election, same as any private citizen, so long as the endorsement is made as a private citizen and not as a board member or on behalf of the board itself. So just because you are here does not mean you are stripped of your First Amendment rights of free speech. The advisory opinion from 2014, again, one of those 33 that all came at once. This was, again, one where I think the School Ethics Commission went a little too far. There was a board member who owned and operated a business. and every year he would donate, the business was running blow-up machines. He would donate the blow-up machines to the local Ed Foundation for a fraction of the cost. He basically said, just listen, just pay my workers. I'm not looking to make a profit on this. Just pay them for their time. The Ethics Commission found that because there was a monetary exchange, they thought that could be perceived as a personal gain and cautioned against it. An advisory opinion from 08. A board member who was previously employed by the district and was fired by the superintendent ran, got on the board, then proceeded to file ethics charges against the superintendent, called for a vote of no confidence in the superintendent, was found to have violated the act that they would participate in any discussion or evaluation of the superintendent, because obviously this was a person with a axe to grind. Somebody came on the board with an agenda to settle a personal vendetta. Every now and then some of these students crop up, which is why the advisory opinion put this out there to make it known kind of at the outset. If somebody does conduct themselves in this manner, then the Ethics Commission will bifurcate that person from any personnel decisions. This just does not relate to the superintendent. Sometimes you see board members that may have a student with special needs, may be dissatisfied with the director of special education, not saying that's here, will come on and make an admission to drive that person out of the position. So again, this is why the Ethics Commission sought to put some reins and controls. Maintaining confidentiality, board members have to maintain confidential all matters pertaining to schools. Basically, you cannot discuss what we discuss in executive session out there with the general public. A lot of times, most of the time, we are discussing matters involving contractual negotiations, be that with the local associations, or talking about matters involving student or staff privacy, and those have to all be maintained confidential by law. Some cases here, you had a board member violate this code by publicly posting confidential information that a staff member was removed from the school and hospitalized due to a medical condition, and actually listing what that medical condition was on social media. You had another case in point where there was a thought process that emails sent to a Board of Education were subject to confidentiality, and if they were disclosed pursuant to an Open Public Records Act request, they could not be turned over. The Ethics Commission came in and ruled, no, that's not the case. Emails do not pertain to students. If they are just, community concerns, they have to be released. And in fact, even if there are emails pertaining to students, if there's an Open Public Records Act for them, the Government Records Council has even ruled that it's incumbent upon the board to redact out the student information. So maintaining confidentiality piece deals more with information that you receive relating to staff or students, not necessarily information that the public presents to or sends to you. Board members must consider the superintendent's recommendation. Will vote to appoint the best qualified person after consideration of the recommendation. It doesn't mean, no offense, Dr. Alcohol, everything I say is Bible and verse. For all personnel matters, board members are allowed to take certain factors into consideration, but they must take into account the superintendent's recommendation. By law, nobody gets hired or fired from the school district or transferred without the superintendent's recommendation and the corresponding board action. So just by way of example, the Ethics Commission pointed out that board members would not violate the code when they voted not to reappoint somebody, despite the contrary recommendation of the superintendent. Again, they must consider the superintendent's recommendation. And in one of the more substantial decisions, the Ethics Commission held that the selecting of candidates for district positions and the making of recommendations is the role of the superintendent. Prior to the recommendation, the Ethics Commission advises that board members should have no role in selecting candidates for any position other than that of superintendent. So exception to that being the superintendent consents and allows for board member involvement is permissible. Board members themselves can't demand to sit in on interviews with the district staff. Board members must support personnel and protect them in the proper performance of their duties. Evidence of a violation if a board member took deliberate action that would undermine, oppose, compromise, or harm school personnel and the performance of their duties. This includes superintendent, business administrator, assistant superintendents, all school personnel. So for example, here, a board member violated this provision when he decided to send a letter to the superintendent, copying the president of the state board, the executive county superintendent, and the local newspaper, accusing the superintendent of allowing his employees to violate board policy. Similarly, you had a board member violate this provision when he sent an email to the superintendent, copying his business administrator or the board members that was threatening, intimidating, and it asked the superintendent to provide an accounting of his or her personal leave. And my favorite, in 2011, the president of the board decided after a long board meeting to go home and post on Facebook with a link to the picture of the superintendent saying, quote, "Now we can only do something about the local terrorist that destroys dreams and burns our future." That person was subsequently removed from the board. Happy to report. And the last tenet is that board members will only proceed through proper channels. What that means is they have to, if you receive a complaint, be it somebody in the food store, be it somebody by email, something, or the local market, somebody comes up to you who's complaining about something going on in the schools, you are ethically required to bring that complaint to the attention of the superintendent. You saw before, I was going through the board members exceeded the policy, planning, and appraisal, where they went and undertook their own investigation. It's your responsibility to refer it to the superintendent. If after that happens, it's not resolved, and it then comes to the board through our grievance process that we have here in the district, and it's available on the website, then and only then can the board take action. By way of example, a board member violated this provision when he went to the principal directly in connection with a parent complaint rather than referring it to the superintendent. Another case is a board member violated this by not providing the superintendent with letters because he didn't like the superintendent's management of issues raised in the letters. Instead, he went to other administrators in the districts. Again, the administration of the schools is to be done by the administration. Those are the 10 provisions of the School Ethics Act. I'm going to give them to you in context. As I said at the outset, one thing they have focused on a ton was negotiations and who can and cannot participate. Here in New Jersey, we have 2 laws that principally deal with participation in negotiations. We have the School Ethics Act, and we have the accountability regulations, which were promulgated back in 2008. You have to love the fact that they both deal with the same subject, they both use similar terms, but define them differently, which was a cause of confusion. You look on there, the column to the left is the terms used in the School Ethics Act, quote, members of the immediate family, the term relative, and the term others. The accountability regulation, all boards of education as a condition of receiving state aid had to adopt a nepotism policy that prohibited board members from participating in negotiations if they had a, quote, relative that either worked in the district or worked in another public school district. Relative was the same term, nepotism regs, as appears in the School Ethics Act, but if you compare the left and the right, they are defined considerably differently. The nepotism regulations definition of relative is much, much more expansive than the definition of the School Ethics Act. Within the last year, the Ethics Commission has finally decided that they will end the charade of trying to differentiate between the two, and they indicated that they will adopt the same definition as appears in the accountability regs. So from here on out, a relative is a relative is a relative. So why that's important? Rather than bore you with all the different advisory opinions that have been released about this subject, I made a chart. So if a board member has someone who's an immediate family member, it's defined on this chart, left-hand chart, that works in district, they can't participate in negotiations at all. They are conflicted. If they have an immediate family member who works in a out-of-school district, meaning they work in another school district in the state of New Jersey, they can't participate in negotiations at all. If a board member has someone who's a relative, as defined in this chart, who works in the school district, they are not allowed to participate in negotiations. If they have a relative who works for another school district, they may or may not be able to participate in negotiations, and I'll explain what that means a little bit, because you have to love the main answer. And then we had this wonderful term that up until the last year was never defined. We just had this other, which people really didn't know what that meant. Is that somebody's godchild? Is that somebody's cousin? Is that the paper boy? Who knew what an other was? But we have some clarification as to who and what those people are. And again, just like relatives, it's going to determine a number of factors whether or not you can participate. So, making it simple. If you have a needed family member, as I said, that's a member of the same statewide union, you're excluded. We have not had that issue here on the board before. I don't believe we're going to have that issue going forward this year as well. There was a new advisory opinion that was just released this year. Again, even though it has a 14-day, and it is, I think, very important because we are seeing more and more of these types of services in districts throughout the state. The question came up was if a board member has a spouse or a relative that is employed by a substitute staffing agency. There's a number of those companies that have popped up all across the state. Does that preclude the board member from participating in union negotiations? And does that preclude the board member from participating in any decisions regarding those that may supervise the spouse? And the Ethics Commission this past, I believe it was this past summer, released the decision saying, no, if they are not direct employees of the district, then there is no prohibition, and those board members couldn't participate. And I apologize, it's actually on this slide. If a board member has a relative or a family member that's a member of the local unit, they can't participate. And this is all reflected in the chart. I give this to you as a reference. Others. Who are the others? Okay, so go back to our lovely chart. Others under the School Ethics Act have been defined now this year to be everybody who is a relative under the Nepotism Act. So again, a relative is a relative, and now a relative is also an other. So if you just check off there, if you have any of these folks that are employed in this district or in other districts, please see me, we'll chat, and we'll chart out what preclusions may present themselves. Another question that came up this year, which was actually very interesting, we've had more and more schools in the state of New Jersey start to, leave NJEA and seek other union affiliations, whether that be the American Federation of Teachers, there are some AFL-CIO, there's also some that some support staffs that are affiliated with the Teamsters. And the question came up, well, what if a board member is a member of what's called a non-traditional, non-educational union? Is there a prohibition that precludes? So if a board member was a member of AFL-CIO, for their job, they'd be precluded from negotiating against the NJEA? The answer is no. The Ethics Commission clarified that, and it's no, so long as that union that the board member is a part of is not in the district and is representing one of the local associations. That was something that they clarified this past summer. Staff, like board members, are permitted to endorse candidates for the board. If a local association does come out and formally endorse, not individual members, but the association itself, come out and endorse a candidate, and the board is entering negotiations, that person who's elected cannot participate in negotiations. The doctrine of necessity, for some reason, this was a hot topic with the School Ethics Commission within the last 12 months. What it basically, the most simplistic element means is that where the board has so many members that have a conflict, that the board itself cannot act. So we have many members, we had 5 members who had conflicts. The board would then invoke the doctrine of necessity, which would then allow everybody to vote, regardless of conflict, so that we would have enough members that we could actually vote tonight. A condition for voting, for adopting the doctrine of necessity, anytime it is invoked, the Board of Education is required to send a copy of the resolution adopting the doctrine to the School Ethics Commission and to publicly post notice that they have adopted the doctrine for 30 days. Again, we have not had to even close to that here. This I found was entertaining. This was the other advisory opinion this past summer. The School Ethics Commission said that, well, so long as you have at least 2 members who are not conflicted, 2 people can be a committee, but 1 person cannot. So there was confusion whether or not you had to have at least 3 for a board committee, but the Ethics Commission said, no, you can have a committee of 2, just not a committee. And I mentioned this before, I gave this to you just in greater detail, the interview process. The Ethics Commission put limits on the board members' role in serving in that process. Again, it's limited. The Ethics Commission does not want board members participating unless it is granted by the superintendent. The volunteering, as I said before, there was that absolute prohibition, but they have been walking it back ever since. You see there's 2 advisory opinions, and the 3rd, and there was yet another one that was not reported this past year. What the Ethics Commission basically will look at is the degree of involvement that board members have with staff and students. So if you're just going in to discuss and give a presentation, say on a career day, or you'd like to volunteer for a fundraiser that the PTO, PTA is doing, you will become a member of the PTO, PTA. You are not included from it. Again, as long as there is not a high degree of involvement or supervision of students or staff, there will not be a problem. If there's any questions on that, please consider. Superintendent searches. Again, if you are conflicted for personnel matters, the advisory opinions is now clarified. You are precluded from a search. It used to be that if you had a relative that was employed in the district, you were only not permitted to participate in interviews of in-district candidates, but could sit in on interviews for out-of-district candidates, which meant that not every board member was seeing every candidate and hearing the same information. There's an inherent inequity that has been addressed and clarified that if you're out for one, you're out for all. And with respect to shared services, the Ethics Commission had previously ruled that if 2 school districts shared services, a board member was employed in one of those districts, they were not allowed to serve on the Board of Education in the other district because they felt that that would be serving 2 masters and that they would make the board members decide to either give up a paying job or their volunteer. And you can guess how many people chose to give up the volunteer. So the Ethics Commission, in a recently released decision, again, I know it's August 2016, but it was just released this past January, did back off that provision and has relaxed that prohibition. I gave you an email address, our office phone number. I'm here. You guys all know how to reach me. Of course, the nepotism accountability regs. If you have questions, you need to reach out to me. Please just get Tony's authorization or just let Dr. Everett know, and then you can reach out to me directly. Any questions? I know I went long. I'm sorry.
Hey, thank you. While we're all here, we want to sign these. That brings us to our first opportunity for public comments. The board invites thoughts and reactions on agenda items and items of concern from members of our community who are present. Each participant is asked to give his or her name and address prior to making a statement, which should be limited to 3 minutes. All statements should be directed to the presiding officer, and the public comment period is limited to 60 minutes total. Anyone like to?
Hello, my name is Min Chao Lai Zhang. It's good to be sitting here instead of sitting over there. Much more freedom. First of all, Happy New Year, and congratulations congratulations to Dana and Isaac being reelected, and congratulations to Martin for being elected. I'm really looking forward to the new board, to bringing some new thing to the community, and I will be as much as I can involved. Obviously, I cannot guarantee to come to the board meeting every single time, but every time there are important issues, I definitely like to be involved moving forward. So thank you for your service. I know oftentimes after serving 3 years, sometimes we feel thankless. Because no matter what you do, you have people against you, one or the other, but I understand it takes a process. So I think the process itself is most important. As long as we all appreciate and respect the process, have everybody heard, I think the decision cannot be wrong. So again, thank you for your service, and looking forward to the moving forward of our wonderful district. Thank you.
And thank you for the time you spent here.
Hi, good evening. Lydia Vincent, 5 Longford Drive. I just want to wish you all a happy new year and thank you all for your service. I know why I don't know if I just sit here for a couple of minutes and wonder when I cannot leave, and you have to spend all the time, and your service to the community is much appreciated. But I just want to say briefly, I know you're going to be voting on the football cooperative in just a little bit, and while there are issues with with the deal that the NJSIA has brought down for us, I suggest that you vote in favor of it. And I want to thank all of the time that you put into this this issue this past year. But I'm not only a mom with 3 boys that play football, but I'm also the vice president of the Bobcats board. Looking at the computer system that's coming on, football is just really not viable long-term in this community if we have 2 programs. And I think we're losing kids because of safety. And my son had an injury this year as well. And there's issues with football already. And it's compounded when you have kids playing both sides of the ball, playing multiple teams. It's just too much. So while there are issues with the cooperative, I think we have to take this important step towards that and hopefully get this piece of legislation and move it forward where it really needs to be. But I think we lose credibility if we don't take this step forward and make this change. So I want to thank you all for the courage of standing up, for the best interest of our student athletes. This is for football in one step. We'll look at our long term for all of our student athletes that deserve the opportunity to play and the participation of this right here. So thank you, and I encourage you to vote yes. Thank you so much.
Thank you.
Johnson, 5 Terrace in Windsor-Plainsboro. I want to say thank you all for your continued support of the student athletes in this town. We're extremely fortunate to have all this backing, and I am part of the high school North football district president. And the support that we've gotten has been overwhelming from the community, from the board, from the administration, and especially from Dr. David Alcohol. So thank you. We're doing everything from drafting up the bill to going out to the Senate and speaking and really getting the media attention around this because it's a huge win for student athletes. People have to realize that they have that community support, that they do they realize they have support. So thank you, and this is not only for football, it's for, I have 2 boys. They do wrestling, lacrosse, track, so all about all the sports, and they mentioned on engineering 101.5 today, maximum participation, minimal injury. So that's what we're going to do. Thank you.
Thank you. Anyone else? Okay, we'll close the public comment period then. We have no committees meet since our last meeting. So that brings us to administration. Can I have a motion on items 1, 2, and 3? Isaac and Michelle. Any questions or comments on the administration items?
I have a question about the football. I'm looking at this chart about injury statistics. Concussions in 2015 were 1, in 2016 it was 2, in 2017 it was 5. Do you have any idea why that's increasing? This is South football injury statistics.
I have my assumptions. I don't have any direct knowledge to the injury, but North did not play varsity season.
This is South.
Oh, I know.
Okay.
North, you notice North stayed relatively stable with 1-0-1. South did have an increase, and when we talked about putting undersized, undermanned players, South, why they had the numbers, they still had some younger players on the field. So my working assumption is that you have students undermanned and undersized, which is exactly why we wanted to enter into a cooperative agreement, so that we can have students playing at the appropriate levels. What the cooperative agreement will do is allow us to have 3 specific levels, freshman, JV, and varsity, actually in the true developmental program, and let students play at the appropriate size and the appropriate weight. When you have, let's say, 5 linemen, and maybe 5 upperclassmen linemen, and one gets injured, now you're in a position where you have an undersized, undermanned person having to step into the roster because you just don't have the depth of the team. The hope with the cooperative is that between the 2 schools, we will have enough players that are viable 3 levels. So my hope, football is inherently a violent sport. So I can't assure that numbers of concussions will decrease. There is, anytime you have physical contact, the potential for injury, whether that's, believe it or not, cheerleading ranks amongst one of the highest for concussion, soccer, wrestling, lacrosse, football, all sports with higher level concussion possibilities. But that's my working assumption, Carol. I don't know the specific injuries. But I do think it's a cause for why we want to go forward.
So you think that by having a joint program, that this number might go down?
That's my hope. That's my hope. Part of our argument along has been to put sort of the students at the appropriate. We have a parent in the audience whose child is a freshman, who's a varsity starter. They'd be the first one to tell you that while their child is athletic and skilled, by no means should they have been a varsity starter. And it's just simply because, one, that they're an incredible competitor. 2, they have that heart and drive that our students possess. But ultimately, it came down to the numbers, that our team didn't have the numbers a year ago in order for them not to be on the field. Actually, that was 2 years ago, to be on the field. So now that we're aware of the concern and problem, parents, the coaches, and the students have spoken and come forward, we believe this is the right thing to do for long-term viability and safety of our students.
And are you anticipating that there will be enough students combined for 2 years to have all 3 teams?
We do believe that based on our current freshman, sophomore, junior numbers rising, and based on what we anticipate coming out of the Wildcats in 8th grade, we have been in touch with the Wildcats program as well.
Any other questions?
I was just going to say one other thing. In the school district, we think in terms of about 3,000 high school students. We're talking about 2% of our students playing a sport. So long-term viability, I do believe that we will have the ability to maintain a program of about 2%, which is about 60 athletes. We can maintain 60 athletes across, that's 15 students per grade level. We can maintain 15 students between 2 high schools per grade level. We can maintain a 3-sport program, freshman, JV, varsity, long-term. Ideally, when we look at other programs, like a Steiner, they would have close to 80 to 100 athletes on a program in one high school of half the size. So we're talking about trying to ensure that we have same number of athletes that we're competing against. And again, that gets into safety, repetition, numbers. So yes, we do believe long-term, if we can co-op, we can save the sport. And as one of the speakers said, this is bigger than football, and that's what the provision of the bill going forward. Tonight, what you're voting on is specifically around football, but the larger, bigger picture argument with the NJSIA and ultimately the legislation that's being presented at the Assembly and the Senate has everything to do with the viability of some of our programs. If we look at our wrestling teams, while we're seeing a surge back at North right now, there's been years where we forfeited every match before we began. Because of the weight classes, we would only have 6 to 8 wrestlers. So when you start looking at those kind of numbers, you get concerned about or students wrestling up or up in weight class and being underweight in order to try to earn points. And that's not ideal for what we're talking about when we look at student safety.
So do we have a plan yet, assuming that we pass this, for how we're handling marching band and cheerleaders? My general understanding is that we were continuing them as separate. Could you just elaborate on the thinking at this point?
Yeah, thank you for asking that. So there have been some questions raised, like if you co-op football, do you have to co-op cheerleading and marching band in particular? And the answer is no to that. We see no reason why we have to co-op those programs at South and North, but there is a reason to bring them together. So some things you might look at. If we have 4 home games, you may play 2 at South, 2 at North. At the times when you're at North, you may have the North marching band perform the halftime, but there's no reason why you couldn't have a shared pep band with shared music across the 2 programs. Cheerleading is much more than just cheering for a football game. There's also the idea of preparation for the winter season and the competition-based season that follows. So there may be a reason to have shared cheers, shared halftime, shared performances, but also maintain individual practices. So it's something that we've talked about. We haven't fully developed by any means. It will be working with the coaches and the marching band directors from both schools to ensure, but the intention right now is to keep both programs for cheerleading and marching band going at both high schools, and then have shared experiences where they're supporting the football program.
Dave, I have a question. One ice hockey parent, he said if the North and the South ice hockey team merged in the future, if parents want to separate, is it possible?
So hockey's a little bit different. Under the NJSI rules, ice hockey is one of the only sports that's actually allowed to co-op at any level, at any group size. North and South ice hockey have been merged. This is now the 2nd season. Based on numbers, we would have to determine whether we can viably maintain 2 separate programs. I can tell you in the past, I believe it was South with Ewing, and I want to say North with, I forget who North was with, quite frankly, but North and Ewing, North with Ewing and South by itself. So we've had, just based on numbers, so it has to be looked at on a 2-year scheduling cycle, and that's the way the cooperative agreements work. Cooperative agreements by the NJSA regulations and bylaws require you to look at a 2-year scheduling cycle. So there's projections out. So now that we're finishing, we're in year 2 of a 2-year cycle for hockey, we have until, I believe it's May 15th or so, to enter into a requested cooperative agreement again. If that is made, it would be coming back to this Board of Education with the agreement, with a resolution, just like it's on tonight for football.
Thank you so much. And also, I want to thank you so much for the working hard on this. I'm the only football parent for them. So on behalf of my kids and my family, thank you so much.
I have a question. Did you say that we have a co-op with Ewing for baseball?
We did in the past. So it was hockey. So it was North hockey with Ewing hockey. South was separate. 2 years ago, we made the determination, based on numbers, to combine North and South hockey. And the feedback after last season was that we saw a more viable team with multiple athletes, with the idea of skating 3 true lines and having more of a development aspect for the underclassmen, for the freshmen and the sophomore. Years before that, it was possible that you'd have very beginner skaters on the ice because you just didn't have the true numbers. Why we co-opted with Ewing, that was about maintaining their program. And again, hockey's a little different because the NJSI recognizes that for hockey, they're trying to maintain the preservation of that sport across the entire state. So they let cooperatives happen between programs as well. So co-op, because we have 2 high schools, a lot of times we think that cooperatives are only internal. But if North was viable and South wasn't, South could co-op with Lawrence or Ewing, or if they needed a partner district. And sometimes you can actually enter into it with 3 districts to keep programs alive.
Any other questions on the administration?
I'm just wondering, it says in your letter
I look at the 2017 football season, there were 87 documented injuries, 6 concussions, 4 broken bones, 1 patella dislocation, 2 lacerations requiring stitches, 2 anterior cruciate ligament tears. Is that typical for a normal year? Is that high? Is that low? Well, how does that compare?
It was an increase over the prior year. I'd have to recount the numbers. But it's no matter what, to me, it should be something of concern. I mean, it's a tremendous number of injuries when you're talking more than an injury per athlete. That's documented. Right? And this is not the normal just bumps, get a bag of ice type of injuries, or the intentional like twist an ankle out in practice. Type stuff, go home and ice up. This is documented by the trainer, logged for injuries. So that's significant. I mean, I have concern when I see 87 injuries.
Any other questions?
For the injuries, I think I can answer some of Carol's questions. This year, on December 7th, I think at the end of November, on the extreme cold Friday night, the competition between North and South was extremely fierce. So there were, among the 3 captains from High School South, 2 got injured and were sent to the hospital. I think it's very random. It's not concussion, it's because of the leg injury. So I think it's because of the competition. Coach Harris is here. If you want, you can share some light here.
No.
Okay.
Thank you. Okay.
Okay, that's it. Thank you.
All right. Are we ready to vote?
Mr. Chang? Yes. Ms. Hurd?
I'm going to abstain because I'm concerned about concussions.
Okay.
Just number 3,
On
concerns or
On the co-op.
on the call, that was number 3. So, 1 and 2?
1, yes.
Okay.
Ms. Juliana?
Yes?
Ms. Groot?
Yes.
Mr. Whitfield?
Yes.
Mr. Taylor-Johnson?
Yes.
Ms. Cage?
Yes.
Mr. Flaherty?
Yes.
Also yes.
Oh, sorry.
We have no further on finance. Can I have a motion on items 1 and 2? Rachel and Taylor. Any questions or comments on those 2 items?
We'll start with Ms. Hurd. So,
Yes.
Ms. Juliana?
Yes.
Ms. Groot?
Yes.
Mr. Whitfield?
Yes.
Mr. Taylor-Johnson?
Yes.
Mr. Chang?
Yes.
Ms. Cage?
Yes.
Mr. Flaherty?
Yes. Okay, personnel, I have a motion on item 1 plus the green addendum sheet. Louisa and Martin. Any questions or comments on the personnel?
Okay, we'll start with Ms. Howe.
Yes.
Ms. Juliana?
Yes.
Ms. Groot?
Yes.
Mr. Whitfield?
Yes.
Mr. Taylor-Johnson?
Yes.
Mr. Chang? Yes. Ms. Hurd? Ms. Cage?
Yes.
And Mr. Flaherty?
Yes. Any liaison reports? Any new business? Second opportunity for public comment. 15 minutes will be provided at the end of the meeting for public comments. Each participant is asked to give his or her name and address prior to making a statement, which will be limited to 3 minutes again. And all statements should be directed to the presiding officer. Okay. I'll close the public comments. Can I have a motion to adjourn?
Aye.
Taylor and Martin? Those in favor of adjourning, say aye.
Aye.
Opposed? Okay, thank you both for coming out.